All right. Welcome to your deep dive into UK criminal law defenses. We've been going through UK criminal law,
Yeah.
and now we're zeroing in on defenses. We're using this UK law podcast lecture series. It's really well structured, and it's going to help us make sense of this.
You know what's really interesting about this area is that it's not just about saying I didn't do it. It's more about like all the little details of intent and circumstances and how the legal system tries to balance justice and individual rights.
So it's like a strategy, right?
Yep.
Like different ways that someone who's accused of a crime can explain their actions
Yeah.
and argue that they shouldn't be held responsible.
Exactly. And those strategies often come down to the type of defense that's being used. So there are general defenses which apply broadly, and then specific defenses which are tailored for individual offenses. So, for example, if someone is charged with assault, they might argue self-defense, which is a general defense. But there might also be specific defenses that only apply to certain types of assault, like consent in very specific situations.
So some defenses are like multi-tools and some are like, a scalpel chosen for very specific situations.
That's a great analogy. And this is where it gets even more interesting. The burden of proof can actually shift depending on which defense is being used.
Wait, I thought it was always on the defendant to prove they're innocent.
Not always. Sometimes the prosecution has to disprove a defense. So take self-defense, for example. If someone claims they acted in self-defense, the prosecution might need to prove beyond a reasonable doubt that the force that was used was excessive.
Oh, okay, so it's not always as simple as innocent until proven guilty. This burden of proof thing can get a little complicated.
It absolutely can, and that's why understanding these defenses is so important. It gives you a deeper understanding of how the legal system works and how these arguments play out in real life.
Okay, let's dive into some specific examples, starting with automatism. You mentioned that earlier, and honestly, it sounds like something out of a sci-fi movie.
It does have a futuristic ring to it, but automatism boils down to acting without conscious control of your body. Like, imagine someone having a seizure and unintentionally causing harm. They might argue automatism, that their body was acting independently of their conscious will.
So it's like their body's on autopilot and they're not really driving?
That's a great way to put it. But there are limitations to this defense. For example, it wouldn't work if the automatism was self-induced, like through excessive drug or alcohol use. There's a famous case, actually, R.V. Lippman, where a man took LSD and killed his girlfriend, and he couldn't claim automatism because he voluntarily took the drugs.
So you can't just like get blackout drunk and then blame it on being in an automatic state if you commit a crime, right?
Exactly. And that actually brings us to another interesting defense, intoxication. It seems counterintuitive to use being drunk or high as a defense, but it can play a role.
Yeah, like saying I was so wasted I didn't even know what I was doing.
It feels a bit iffy, doesn't? It does. But the key here lies in distinguishing between voluntary and involuntary intoxication. Let's say someone slips a drug into your drink without you knowing. That's involuntary, and it could significantly impact your culpability for any actions that follow. There's another case, R.V. Kingston, where a man was drugged and then lured into sexually assaulting a minor, while he was ultimately found guilty. This case sparked a huge debate about involuntary intoxication and how it should impact sentencing.
So if I unknowingly ate a pot brandy and ended up, sleepwalking onto a movie set and like borrowing a prop gun, could I argue involuntary intoxication?
Hypothetically, that scenario would involve involuntary intoxication, but let's not encourage any unlawful borrowing of movie props. The point is, in that situation, you didn't choose to ingest the substance, and that could be a mitigating factor in your defense.
Okay, back to lawful scenarios.
Yeah.
What of the defense of mistake? Is that simply claiming that you didn't know something was illegal?
It's a bit more nuanced than that. Remember, mens rea, the intention to commit a crime. The defense of mistake centers around proving you made a genuine, honest mistake that negates that intent.
Okay. So not just ignorance of the law, but like a genuine misunderstanding of the situation. Like thinking you're borrowing a friend's bike with permission when they never actually said yes.
Exactly. In that case, you might not have the mens rea for theft, as you genuinely believed you had permission to take the bike. But proving that genuine belief can be tricky.
Right. So it's not just about saying, oops, my bad. You need to like show that your misunderstanding was reasonable and genuine.
Precisely. And that's why legal representation is so crucial. A good lawyer can help build a strong case that highlights these subtleties and presents your actions in the most favorable light.
All right, let's move on to self-defense. This one seems pretty straightforward. You're being attacked, you defend yourself, end of story, right?
Well, it's a widely recognized defense, but it's not that simple. There are specific requirements. The force you use has to be necessary, proportionate to the threat, and based on a genuine belief that you're in imminent danger.
So if someone shoves me, I can't exactly whip out a taser, right?
Probably not. That would likely be considered disproportionate force. The
Uh,
key is that the force used must be reasonable given the circumstances. There's a classic case, R.V. Palmer, where a man who shot and killed a pursuer during a robbery was convicted
mhm.
because the court found the force used to be excessive.
Okay, so it's not a free pass to use any force that you want. The court will carefully consider whether your actions were truly justified. But what if the attacker is much larger or stronger than you? Does that change things?
That's definitely a factor considered by the courts. If a smaller person is facing a much larger aggressor, they might reasonably believe they need to use more force to defend themselves.
So it's not just about the objective level of threat, but also about the individual's perception of that threat.
Yes, it ties into the concept of reasonable belief. The court will look at whether a reasonable person in your situation would have perceived the same level of threat and acted similarly.
Okay, so there's a subjective element to it as well. What else makes self-defense tricky?
Well, in the UK, there's no legal duty to retreat, meaning you're not obligated to run away from an attacker before defending yourself. However, the court will consider whether you had the opportunity to retreat. This can be complex as it involves weighing factors like the layout of the location, the speed of the attack, and your own physical abilities.
I can see how that would add another layer of complexity.
Yeah.
So moving on to consent, I assume this mainly applies to assault cases.
You're right. It frequently arises in assault cases, especially those involving sexual assault. The crucial point here is that consent must be freely given and informed. It can't be coerced or manipulated or based on deception.
So let's say someone consents to a boxing match, but isn't fully aware of the risks involved, like the potential for long-term brain damage. Would their consent be considered valid in that case?
That's a great example. If someone isn't fully informed about the potential consequences of their actions, their consent might not hold up in court. The law recognizes that consent must be given with a clear understanding of what's being agreed to.
Okay, got it. Consent is more than a simple yes or no. It's about truly understanding the situation. Now, duress, that sounds like a pretty intense defense.
It is. Duress means being forced into committing a crime because of threats, like someone holding a gun to your head and making you rob a bank.
Yikes. So in that situation, could you actually use duress as a defense?
Potentially, but the conditions are very specific. The threat has to be immediate, and it has to involve death or serious bodily harm. You also have to genuinely believe that the threat will be carried out, and that a reasonable person in your situation would have acted the same way. The case of R.V. Hassan is often cited here, as it clarified the limits of duress, particularly the requirement for an immediate threat.
So it's not just about feeling pressured. It's about like a real and immediate danger and proving that you had no other choice but to comply.
Exactly, and it's crucial to note that duress cannot be used as a defense for murder. The law doesn't recognize a situation where taking one life to save your own is justified under duress.
Wow, that's heavy. It highlights the ethical complexities at play in these defenses.
Oh.
All right, last one on our list for now, insanity. I imagine this involves pretty complex psychological evaluations.
You guessed it. The insanity defense is rooted in the idea that a mental disorder prevented someone from understanding their actions or recognizing their wrongfulness. We're not talking about being a bit eccentric. We're talking about a severe impairment of mental function.
So if someone truly believes that they're being controlled by aliens and commits a crime based on that belief.
That could potentially be a case where the insanity defense is explored. But again, it would require a thorough evaluation by experts to determine if their mental state truly prevented them from understanding the nature and consequences of their actions. The famous case of Knighton back in 1843 established the basic test for legal insanity, and it's still influential today.
It sounds like proving insanity is a really high bar to clear.
Yeah.
What happens if this defense is successful?
If the court accepts the insanity defense, the verdict isn't just not guilty. It's a special verdict, not guilty by reason of insanity.
And what does that mean for the individual? Do they just walk free?
That's a great question and a good place to pause for now. We'll delve into the implications of an insanity verdict and explore some more intriguing aspects of UK criminal law defenses. When we continue our deep dive, what's really fascinating here is that a not guilty by reason of insanity verdict doesn't mean the person is just, released. They're often subject to measures like indefinite detention in a psychiatric facility or ongoing monitoring by, mental health
So
professionals.
it's not a get-out-of-jail-free card,
Yeah.
but more like a recognition that their actions came from a mental disorder,
Yeah.
rather than like criminal intent.
Exactly. It reflects a nuanced understanding of culpability and the complex relationship between mental health and criminal behavior. It doesn't, erase the need for intervention, but it acknowledges the underlying mental health issues that contributed to the offense.
That makes sense. It's not about uh, absolving responsibility, but understanding the context of the individual's actions. Now, let's talk about partial defenses. I find these really intriguing because they don't completely erase guilt, but they can significantly impact the outcome of a case.
You're right. They can be game changers. Think of them like a dimmer switch on a light. So instead of turning the light completely off like an acquittal, they can lower the intensity,
Yep.
reducing the severity of the charge.
Okay, I like that analogy. It helps me visualize how these defenses work. Can you give me some examples of when they might come into play?
Sure. Two common ones are provocation and diminished responsibility. Let's say someone is charged with murder but argues they were provoked into the act. Maybe they were subjected to, like, extreme and persistent bullying, or witnessed a loved one being harmed. If the court accepts this defense, the charge could be reduced to manslaughter, which carries a lesser sentence.
So it's about acknowledging that their actions, while wrong, were influenced by external factors, even if those factors don't fully excuse their behavior.
Precisely. It's recognizing the complexity of human emotions
Hmm.
and how intense situations can impact our actions. Diminished responsibility works similarly, but focuses on internal factors, specifically a mental condition that impairs judgment or self-control.
Can you give me an example of how diminished responsibility might work in a real-world scenario?
Sure. Let's say someone with severe depression commits a crime during a period of intense mental distress. Their ability to think rationally and control their impulses might be significantly compromised. They might argue diminished responsibility, acknowledging their actions but highlighting the role their mental state played. Think of the case of R.V. Byrne, where a man with irresistible impulses killed a young woman. He was convicted of manslaughter, not murder, due to diminished responsibility.
So it's like saying, I did it, but I wasn't fully myself at the time. It acknowledges responsibility, but highlights the mitigating circumstances.
That's a great way to put it. And in both provocation and diminished responsibility cases, the goal is often to reduce a murder charge to manslaughter. It doesn't erase their responsibility, but it takes into account the factors that contributed to their actions.
Okay, I'm starting to see how these defenses can be so crucial in ensuring a fair outcome. But these partial defenses seem a bit subjective. How does a court actually decide if someone was truly provoked, or if their mental state was genuinely impaired?
That's where it gets really complex and where legal expertise becomes vital. The defense has to present compelling evidence, often including eyewitness testimony, psychological evaluations, and detailed accounts of the events leading up to the crime.
It sounds like a legal puzzle, piecing together all these different factors to paint a picture of what happened and why.
You're exactly right. And remember, the prosecution will be doing the same thing, trying to demonstrate that the defendant acted with full intent and responsibility. They'll scrutinize the evidence, challenge witness accounts, and present their own interpretation of events.
So it's a legal battle, with each side trying to convince the judge or jury that their version of the story is the right one.
Exactly. And the outcome can hinge on seemingly small details, the credibility of a witness, a single piece of evidence, the way an argument is presented.
The stakes are high. It's a reminder that these aren't just abstract legal concepts, but like real-life dramas unfolding in courtrooms, impacting real people's lives.
Absolutely. And that's why understanding these defenses is so crucial, even for those of us who aren't lawyers. It provides a window into the legal system's inner workings and the delicate balancing act between protecting individual rights and upholding justice.
Okay, we've covered a lot of ground here. We've delved into automatism, intoxication, mistake, self-defense, consent, duress, insanity, and even partial defenses like provocation and diminished responsibility. I feel like I've gained a much deeper understanding of these defenses.
Yeah, we've certainly journeyed through some key territory in UK criminal law, but we've only scratched the surface. There are many more fascinating nuances and real-life examples that could bring these concepts to life even further.
I'm eager to hear more. As we transition into the final part of our deep dive, I'm wondering what else you think is important for our listener to know about the broader context of these defenses.
As you continue to explore UK criminal law, it's important to remember that the law is a living, breathing thing. It's constantly evolving and adapting to societal changes and new understandings of human behavior.
That's an interesting way to put it. So it's not just about memorizing a set of rules. It's about understanding the principles behind them and how they're applied in real-world scenarios.
Exactly. Think of it like learning a new language. You can memorize vocabulary and grammar rules, but true fluency comes from understanding the nuances of the language, how it's used in different contexts,
Yeah.
and how to express yourself effectively.
I like that analogy. So how does that apply to understanding criminal law defenses? What's like the next level of understanding?
Well, we've explored some key concepts and examples, but the real learning happens when you start connecting the dots. For example, we talked about self-defense earlier. But what happens when self-defense intersects with other factors, like mental health?
That's a good one.
Yeah.
You mentioned PTSD earlier. What if someone with PTSD is triggered and in that state of like heightened anxiety, they use force against someone they perceive as a threat?
Hmm.
Could they still argue self-defense?
That's a complex scenario, and the answer isn't always clear-cut. The court would have to consider several factors: the severity of the PTSD, the nature of the perceived threat, the proportionality of the force used, and whether a reasonable person in that situation experiencing those same PTSD symptoms would have reacted similarly.
So it becomes a question of whether their PTSD genuinely impacted their perception of the threat and their ability to respond proportionally.
Exactly, and that's where things get really interesting. The law isn't just a rigid set of rules. It's a framework for interpretation and judgment. It requires understanding the context, the individual circumstances, and how all these elements come together to shape the narrative of the events.
That makes it sound like a real-life detective story where lawyers are like piecing together clues to build a convincing case.
That's a great way to think about it. And just like in a detective story, the outcome isn't always predictable. Different judges and juries might interpret the same evidence differently, and legal arguments can be crafted in various ways to highlight different aspects of a case.
It really highlights the importance of skilled legal representation and the ability to like present a clear and persuasive argument. It's not just about knowing the law, it's about knowing how to use it effectively.
Absolutely, and it reminds us that the law isn't always black and white. There are often gray areas, room for interpretation, and the potential for different perspectives to clash. That's what makes this area of law so fascinating and dynamic.
It's about the human element, isn't it? The stories behind the laws, the complexities of human behavior, and the search for a just resolution.
You've hit the nail on the head. It's about understanding that every case is unique. Every individual has their own story, and the law must be applied with sensitivity and nuance.
This has been such an insightful deep dive. We've gone from broad concepts to specific examples, and I feel like I've gained a whole new appreciation for the complexity of UK criminal law defenses.
It's been a pleasure to explore these concepts with you. As you continue your exploration of this area of law, I encourage you to keep asking questions, digging deeper,
Yeah.
and looking for those aha moments that illuminate the intricacies of this fascinating field.
So to wrap things up, what's the one key takeaway you want our listener to remember from this deep dive?
I hope you remember that these defenses are more than just legal loopholes. They're fundamental safeguards that protect individual rights within the framework of the law. They reflect a commitment to fairness, due process, and recognizing that human actions are often driven by complex and multifaceted factors.
That's a powerful takeaway. It reminds us that the law isn't just about punishment, but about understanding, balance, and pursuing justice. That takes into account the full spectrum of human experience.
Well said. And as you delve deeper into the world of law, keep challenging assumptions, exploring different perspectives, and enjoying the journey of discovery.
And there you have it, your deep dive into UK criminal law defenses. We've covered a lot of ground, explored fascinating examples, and hopefully sparked some new insights for you. As you continue your legal journey, consider this. Do you think these defenses strike the right balance between protecting individual rights and upholding the law? Food for thought.